Hi, and welcome to YP-CDN Town Hall. We have set up this town hall discussion for our members to join in a discussion online to bring your ideas, find out more about the activities and what you can do to get involved with YP-CDN, get to know other YP members across the globe, and to help us build and continue to create and engage global community organizations. So the idea of a town hall is usually sort of at the local level, that people in a community come together and attendees can present their ideas, voice their opinions, and ask questions in a public forum. And so since we can't all come together because we're in various places worldwide, we're coming together virtually. The idea really is that we want to bring different topics into discussion for our town hall sessions, and then really get to know you and get into a discussion about issues related to NCDs and social justice and health policy. So briefly, my name is Jordan Jarvis. I'm the Executive Director of the Young Professionals Chronic Disease Network. I am currently coming to you from Boston in the US. Maybe we'll go around and do a round of introductions with everyone on the call here. I'll just introduce actually our guest speaker today. It's Fiona Lander. I'm sure she can say briefly a few words as well, but she's a medical doctor and lawyer presently working as a human rights consultant for the United Nations Office of the High Commissioner for Human Rights in Geneva. Fiona teaches globally in health and human rights, including at the Copenhagen School of Global Health, and is a commissioner for the Lancet Youth Commission on Essential Medicines Policies. She recently finished her Master's of Public Health at Harvard University, and that's actually where I met Fiona, here in Boston. And she has spent time previously working in India with the former United Nations Special Rapporteur on the Right to Health, Anne Grover. And she also worked as a commercial lawyer and as a doctor in Melbourne. So Fiona has many, many skills that we're excited to hear about today. So maybe if you have anything else to add, Fiona, say hi to the network. Nope. And then we can go around and everyone else can introduce themselves.
Hi everyone, it's really great to be here today, and I hope you can get something useful out of my talk on essential medicines for non-communicable diseases.
I'll hand it to you, Desiree.
Of course. So my name is Desiree Neufeld, and I'm involved, I guess, with YP-CDN for the past year, and had the good fortune of meeting Jordan a few years ago in Nairobi while I was doing a practicum for my Master's of Public Health. So since then, I've been working to support various activities and initiatives, including YP Speaks, through our network and our membership body.
Great. Pooja?
Hi everyone, my name is Pooja Yaramilli. I'm a medical student at the University of Pennsylvania in Philadelphia, and I've worked with the Young Professionals Chronic Disease Network for about a year, and I was managing the Access to Medicines projects, and right now I'm kind of diving back into medical school.
Great. So since we can't really see anyone who's new to YP-CDN, we'll leave out that discussion at the moment. But really, I just wanted to emphasize that what we hope to provide with YP-CDN is a bridge between the local and the global. So to build local or enable local action on NCDs for young professionals, people who are doctors, researchers, physicians, sorry, I've already said that, lawyers, and in other fields to work with policymakers at the local level to impact policy and social change and build accountability, and really to bring those experiences also to the global policy discussion table. The real real experiences from people on the ground in terms of what changes are happening, and to connect those two. And so why do we emphasize NCDs as a social justice issue? Well, it's because they cause millions of preventable deaths, particularly in less developed nations. They disproportionately impact impoverished populations, locking people further into poverty, and cause catastrophic consequences for individuals and societies alike. And so particularly in relation to access to essential medicines, there's been more recently this issue has been highlighted as a human rights issue, again with the creation of the UN High-Level Panel on Access to Medicines, where they also noted that despite progress made in many areas, millions of people are still left behind and dying because they lack access to life-saving medicines. And so this particularly includes 38 million people that have died from NCDs in the past year, actually. And so a lot of the access to medicines initiatives in the past 20 years have really been focused on communicable diseases, and now we're really hoping to scale up the access to medicines movement for NCDs as well. And that's where we hope that our members will join us and really play a role at the local level and join in the global discussions and informing global policy discussions. So on that note, maybe I'll see if, Pooja, do you have any sort of thoughts to add in terms of more generally access to NCD medicines, and so what got you excited to be involved in our work?
Sure. I think you hit the main points, but I think one thing that struck me that first got me involved is that, like, obviously these are chronic diseases that don't go away. So chronic diseases means chronic cost for a lot of families around the world. And it's also a really interesting time because we're seeing, like, trade agreements like the TPP, and we're seeing pharma coming into the news more and more, and the nuances about pharmaceutical regulations and policies. So that's kind of what drew me to, like, the field of access to medicines. And I think now's a really good time to get involved because a lot of people are starting to kind of try to learn more about it and advocate on behalf of patients.
Yeah, definitely. Especially with the Martin Shkreli case here in the U.S. That you may have heard about, the pharma bro who marked up one of their medicines. I forget what percentage it was. It's something like 75,000% or something. And there's a lot of these instances of profiteering and just racking up the cost of medicines for no particular reason. And I think we've really reached a point where people are outraged enough in both high-income countries and developing countries to say, why is this the case, and does this system of R&D and providing medicines to people still serve the public? So that's a big question, and on that note, I'm going to pass it off to Fiona to talk to us a little bit about access to medicines and human rights, and why it's important and how we can continue to build the discourse and the framing of human rights and essential medicines.
Thanks, Jordan. Well, I wanted to start off with an introduction today about the human rights framework that we're working within, because people aren't necessarily aware of that, and that's the, I suppose, most easy entry point to start from. It's important to recognise that when we're talking about the human right to health, which includes accessing certain essential medicines, we're looking at both the international and the national level. So I'll start off by talking about the international level. Now, a lot of people would have heard of the International Covenant on Economic, Social and Cultural Rights. That's the treaty that was created, which includes the international right to health, as it were, in Article 12. Now, Article 12 itself is quite short and doesn't necessarily mention access to medicines specifically. It does mention that states are obligated to create conditions through which the populace can access medical services. What we do know through the Committee on Economic, Social and Cultural Rights, through their General Comment number 14, is that essential drugs are considered one of the core obligations that a state has to meet. So what they mean by that is that it's one of the minimum things that a state is supposed to deliver to its citizens. And when we talk about essential drugs in the language in General Comment 14, it actually refers to the WHO model list of essential medicines. Now, this raises some interesting questions because the right to health internationally is a right that doesn't necessarily have to be immediately realised. We talk about the principle of progressive realisation. And what we mean by that is that states aren't obliged to necessarily deliver a perfect health service instantly, because of course that's not within the capability of many states, in fact probably not all states. So what we say is that states instead are obliged to take progressive steps towards delivering all of the goods and services and facilities that people need in order to attain the highest attainable standard of health. Now, the question then arises, what does that mean for states? What should we say that their obligations are in respect of essential medicines? It's a tricky question. Now, we know from General Comment 14 that states should make essential medicines one of their priorities in delivering services to people. But we also know that the WHO model list of essential medicines has become very broad. In recent times, drugs which are more expensive, such as the newest drugs for hepatitis C, have been added to the list. And realistically, at their current price point, these are beyond the reach of many countries, particularly in the developing world. How do we deal with this? It's a tricky issue. We do have some guidance from the national level, however, which is the second point that I wanted to discuss with you. Because even though we have the international treaty, which concerns the right to health and contains essential medicines within it, that's often not directly enforceable because of the way that laws are structured throughout the world. It's a little bit complex, but when a country signs a treaty, it doesn't necessarily become part of national law. So not every country in the world has an automatic right to health which is justiciable. And what we mean by justiciable is that you can actually take the government to court for a failure to fulfill the right to health. So a number of countries in the world at the moment have a right to health within their constitution. Many of these countries have adopted a right to health which is very similar to the right at the international level. For instance, countries such as Kenya and South Africa have similar wording. Other countries also have a right to health. So, for instance, in Latin America, there are many countries that have a right to health in a constitution or equivalent document. And what that allows in many cases is for individuals to actually bring litigation, bring a court case saying, why don't I have access to this particular medicine? It's my right under the laws of a specific country. And one case I wanted to tell you about today was the really landmark case back in the early 2000s of TAC, Minister for Health, which was heard in South Africa. And in that case, this did not concern NCDs, but it actually concerned access to antiretrovirals back when they were still very expensive. A group brought a case to the highest court in South Africa, arguing that women who were pregnant should have access to antiretrovirals to prevent transmission of HIV to their babies during birth. So effectively prevention of mother-to-child transmission. The South African government defended itself in not giving access to these medicines by saying that it didn't have the resources and that in any event, women were probably going to pass on the illness to their babies through breastfeeding, so what was the point of mother-to-child transmission? Now, I won't summarise the entire judgment, but the court actually found in favour of the plaintiffs in that instance. They found that the government hadn't taken sufficient steps to guarantee access to this medicine. And what they found was, although the right to health is progressively realisable in relation to essential medicines, that doesn't excuse a government from not acting. So even if a government is constrained by resources, they've still got to come up with a plan as to how they're eventually going to deliver these medicines over time. At the very least, they have to have thought about it. So that's one of the core messages to take from this case, that even though access to the medicines may be something that's progressively realisable, something like a national plan is an immediate obligation and cannot be gotten out of by governments. So this learning is really important for activists around the NCD area, because we can look at countries that have a justiciable right to health and we can say, okay, why haven't these countries enabled access to things like opiates for pain relief in palliative care, or diuretics for hypertension, that is high blood pressure? These medications are inexpensive and often readily available, so why hasn't the government necessarily come up with a plan to deliver those? That's something that could potentially be looked at. Having said that, I do want to also look at the potential downside of litigation in this area, because it's important to note. We've seen a phenomenon, particularly in Latin America, where there have been hugely increasing volumes of litigation in order to secure access to medicines. And in fact, this is more relevant to the NCD area, because in countries like Colombia, Brazil and Costa Rica, patients have been taking their governments to court and saying, I want access to these novel cancer medications or untested medications that perhaps, like say chemotherapies, that don't have a lot of evidence for their benefits, and saying this is part of my right to health. Now, this isn't strictly true, but because of a lack of capacity within judicial systems in these countries, where right to health is perhaps relatively new, or there's not as much experience within the judiciary, the experience of people is that generally judges will just find in favour of the plaintiff. Not always, but more often than not. And this is actually putting a lot of increased stress on health systems. So as part of my research at Harvard, we were looking at novel ways to deal with this and to try to build capacity within the judiciary to weigh up giving a drug to an individual versus the cost to the broader healthcare system and whether it is actually an essential medication. Because some research from Costa Rica actually indicated that 70% of cases that were brought involved low priority medicine. So where people were successful in bringing a case to access medicines through the court, they were often drugs that were not considered essential medicines by the traditional definition, or were even untested or novel medications. So it's important that we don't look at this and go, oh, well, a right to health doesn't work. That's not the takeaway message. The point is that it needs to work effectively through building capacity in these institutions. And a good example of this actually is in Colombia, where there's a slightly different situation. A lot of the petitions that have been brought in Colombia to get access to essential health services and medicines, in fact 70% of these were for services that should have been offered under the National Healthcare Plan anyway. So what we're seeing is a situation where patients are having to litigate in order to get access to things that they're already entitled to. This is not a useful situation. So the Colombian court has dealt with this in quite a novel way by looking at a lot of cases together. Again, this is an oversimplification, but taking cases with similar factual scenarios, looking at them together, and then over time issuing decisions and injunctive relief and going back and forth with the government and having a dialogue and actually saying, you know, how can we assist the government in making better decisions in terms of resourcing to ensure that everyone gets access to these services, not just the people who are litigating. And that's a really important point, because research again indicates that the people who can afford to litigate are, of course, those of higher socioeconomic status. So in these countries where there's high volumes of litigation, it doesn't necessarily mean that these essential medicines are then getting delivered to the poor because they can't afford to take their government to court. So the Colombian model, where they're engaging in this interactive dialogue with the government and supporting them in changing their policies, is actually a more constructive one than simply issuing separate decisions for every single person who comes along and tries to claim that their right to health has been infringed because they haven't been able to access a particular drug. So what does this all mean for YP-CDN? There's a couple of take-home points that I would make. Firstly, even though we have an international right to health, it's important to note that that doesn't necessarily mean that there's going to be one at the national level. So what I would be saying is that it's important to go and check. Is there a right to access healthcare in your country? Is there a right to access essential medicines? If so, are there organisations you can get involved in which are looking at how to improve access? For instance, in South Africa, the Treatment Action Campaign were the ones that brought this case against the Minister for Health, and they are continually working on access to medicines and ways to make sure that people achieve their constitutional rights, either through the courts or not. So that's an important thing to first be aware of, and then see whether there are dispute resolution mechanisms that can be accessed in your country to ensure that people can access essential medicines, because often you don't even need to go to court. You can make a complaint to an ombudsman or similar and try and work out another way to ensure access. Another point that I would like to make is that at the international level, there is a mechanism that can be used that's important to know about, and that is the compliance mechanism of the Special Rapporteur on Health. So I worked for the previous Special Rapporteur on Health and am now consulting for the Office of High Commissioner for Human Rights. And the office handles complaints that are made to the Special Rapporteur by individuals or groups about breaches of the right to health. So if in your country, if you don't have a specific right to health, or even if you do, you can always use this mechanism to make an anonymous complaint, and if ideally providing evidence of a breach that's occurred, whether it's, say, a hospital refusing to provide drugs or services to an individual or group of individuals, or governments adopting a policy which you think is inconsistent with the right to health, you can always issue make a complaint to the Special Rapporteur, and then if they consider that there is some merit in that complaint, the Special Rapporteur can then, with the team, send a complaint to the country and ask for further clarification. And in many cases, the countries aren't necessarily aware that what they're doing is in breach of the right to health, or perhaps don't have the capacity to change their policies without assistance. So bringing it to their attention and making it clear that it is in fact a breach can be the first step in changing, say, discriminatory policies that leave out access for a particular group. So those are just a couple of ways in which you can actually take the right to health and put it into action. And yeah, I'd be pleased to take any questions now on if anyone has any in relation to this topic. Thank you.
Thanks, Fiona. That's great. So I have one immediate question, then I'd love for others to field some questions as well. And I believe the Q&A box should be enabled for anyone that might be viewing. So for the Colombian case, you mentioned that there are individual disputes that come up, and do those win? So if someone says, okay, I can't access this cancer medication, does that usually result in a overall lowering of the price of medicine in the country, or just for that individual?
So this is one of the issues. Generally, when individual litigation is brought, usually what it results in is just individual access. And this is one of the criticisms that is levelled against this rights framework, essentially. There are those that argue that essentially there shouldn't be a right to health because it distorts budgetary allocations by governments, because effectively governments say, well, we can't afford to subsidise or provide this drug for free, and then an individual will come and will litigate and say, well, I want access to it, and the government is forced to give it, and they'll only give it to that person. It won't actually have any effect on pricing, and the rest of the population is left no better off. In fact, probably worse, because some money has been taken out of the budget that was allocated to something that the government thought was of a higher priority. Now, this is what we talk about when we refer to, equitable distribution and justice. this is obviously not a situation that is creating the most just outcomes. And so that's why when we look at the Colombian example where they grouped together a bunch of individual litigants and said, right, this is not necessarily going to be about individual damages, this is going to be about fixing the system, that was a really promising step.
Right. And do you know if other countries are also taking similar steps, or?
I mean, other countries have done similar things in respect of other litigation in terms of, you know, like common law countries will often group together petitions that are similar, you know, if it creates an expedient situation for the courts. But in relation to the right to health, I'm not aware of any other countries that have done that. The truth is that in a lot of these countries, the right to health is relatively young. It often hasn't been incorporated into constitutions until recently. For instance, in Kenya, the right to health was only incorporated into the constitution a few years ago. And so we're only just starting to see some of the jurisprudence emerging in countries like that. Of course, other countries have had rights to health for much longer, such as South Africa, and they have more I suppose, a build-up of cases. But it does work differently in each jurisdiction.
Yeah. Do you have other questions?
Now I have a question, and it might be just a technology glitch that I didn't hear correctly. But when you were referring to the Columbia case where they grouped together, I guess, did you use the word litigation or petitions with similar factual qualities? And is there a baseline number for moving forward with a specific issue that would actually get it brought to the table, as opposed to, as you were referring to the term build-up? How long would it take then for an appropriate number of cases to come together, or issues to come together, for it to have enough ground to move forward?
Right. I mean, I don't think that there's necessarily a particular quantum of cases that would be necessary. I mean, when you look at the Latin American context, we're talking about hundreds of cases that have come through with people seeking access to essential medicine. So it's not like there's a shortage of them. I'm guessing that there probably would be a reasonable amount of double up. I'm not really sure of the statistics, to be honest. But I guess this is where it's also important for courts to improve their processes, which is not always easy, because often, you know, many countries, the judiciary can be underfunded. And for instance, I think about my experience in India, where in certain states in India, something like 2/3 of positions on the bench, that is judges' positions, are not filled because they have difficulty finding candidates. People don't want to do the job because the pay is not good enough. You know, there are huge issues in relation to just that basic capacity within these systems. And often what you'll find is that you know, people will bring cases individually, and there'll be a certain number of cases on a judge's docket, but there's lots of different judges hearing cases, and there's not necessarily going to be communication between them about the fact that they're hearing similar cases on the same day. So that's like a process issue, and I mean, I can't really speak to that in a great deal of depth because I haven't worked as a lawyer in that jurisdiction or done that much research there. But I think that this is probably a common problem across a lot of judicial systems, particularly in developing countries where there's just that lack of resources and capacity to perhaps identify really similar cases, join them and hear them collectively, even though that would be a more efficient thing to do. But it would be an interesting thing to research further, definitely.
Yeah.
I see that we have another question that's being typed up, but in the meantime, so Fiona, you mentioned that model lists of essential medicines are included at the global level on the descriptions on the right to health. And I'm wondering if you know also at national levels if there's cases where that might be incorporated in countries that do have the right to health, or yeah.
That's a great question, and I don't know off the top of my head. Now I'm trying to remember the details of the case. I can't recall if the TAC case, for instance, actually used the WHO model list of essential medicines, my feeling is at the time, and this is testing my memory, this was right back when antiretrovirals were very expensive, and it was around the time that very fundamental changes were occurring in the WHO model list, because up until that point, antiretrovirals hadn't been included because of their price, but because of concerted international campaigning, WHO eventually did include them because of the nature of the HIV epidemic and how necessary it was. And following that, but also at the same time, HIV medicine prices started to rapidly drop. Now, I can't recall exactly how TAC fitted in terms of timing, but it may well be that if South Africa had an essential medicines list at that time, the drugs may not even have been on there. So that's something that I would like to go back and check, actually. But, I mean, to my knowledge, I don't know of any cases where the essential medicines list has been used as, say, evidence or as, you know, to bolster an argument that the medicine is essential and therefore should be provided by the government under the right to health. And, you know, it is important to note that there is a significant discrepancy between the WHO model list and a lot of national lists. In fact, many national lists haven't been updated to include all of the WHO model lists drugs, and often that's with good reason, because countries do have the ability to adopt their own list, which is tailored to the individual circumstances in that country, including looking at their own disease burdens. So just because something's on the WHO model list doesn't necessarily mean it should be on the national list. But yeah, I mean, look, it's a really interesting question, and I don't know of cases where it has been used, but I would envisage in the future that would be a very reasonable thing to happen, that if plaintiffs want access, they could point to the essential medicines list and say, well, if it's on here, that's a good argument for providing access. And in fact, that may enter into countries' trepidation in terms of adding medicines from the WHO model list onto their national list, because that might expose them to litigation.
Right. And so the question is it a good thing then, or a bad thing?
Like all things, it's both.
Yeah.
Realistically, it's a difficult thing. And this is where, certainly in our work on the Lancet Youth Commission on Essential Medicines, one priority is trying to work out what is the role of a national essential medicines list. Mm-hmm. Is it supposed to be a basis for procurement? Is it just that every drug on that list should definitely be available within a country, or is it more aspirational? Should countries be putting drugs on there that they're hopefully going to be able to provide access for in the next 5, 10, 15 years based on a national plan? You know, it's a very reasonable question, and I think that this is something that needs further definition, because otherwise definitely that fear of exposing the country to the risk of litigation, I think, would potentially drive inclusion decisions.
Right, yeah. So Pooja's comment here is, it's obviously difficult to successfully argue human rights cases in individual countries, though there are examples of it being done. I was wondering about if and how the human rights and legal framework could be applied on a cross-country level. For example, there was an article in the New York Times today about how Gilead is providing Sofosbuvir at low cost in Egypt, but is tightly regulating its delivery to prevent a black market, which has its own human rights implications, and is using this program as a defense of high prices elsewhere in the world. So how do we approach such complex issues through a human rights framework?
Look, it's really difficult, and you know, it is important that we do look at both the international and national levels, because you're right, just looking at the individual situation in one country isn't necessarily useful when it's much more complex than that. And you know, this, I suppose, I don't want to call it a tactic necessarily, but I think it is a tactic of multinational pharmaceutical companies offering differential pricing. This is really claimed as something very progressive by them. For instance, Gilead saying, well, you know, we're prepared to provide this drug at very low cost in these countries, let's give ourselves a big pat on the back. it's not necessarily done in such a way that's ultimately going to result in realisation of the rights of people who are most affected. So, for example, Gilead has been criticised in relation to provision of this hepatitis C medication for offering, I suppose, a lot of licenses to generic manufacturers in India, but only for them to then on-sell the drugs in the least developed countries. Now, the vast majority of the burden of hepatitis C is actually in slightly higher income countries in the world, so often low to middle income countries, not the least developed countries. And so by doing this and creating this system of voluntary licenses and looking quite altruistic, we're actually seeing a situation where the countries that are somewhat more affluent but still can't afford the prices that are being charged for these medications, they're the ones with the greatest need and they're not getting it. So in terms of how you would then use the international human rights framework, look, it's difficult because the treaty that I was talking to you about, the Covenant on Economic, Social and Cultural Rights, that creates direct obligations for member states because member states are the only entities that can sign that treaty. So even though there are other obligations that arise for, say, multinational companies, they're indirect obligations. So they can't, as we say, like directly be enforced through, say, a treaty monitoring process. Having said that, complaints still can be issued, I believe, in relation to these companies. And one way to do that is actually indirectly. So governments have a responsibility to properly regulate the activities of companies within their borders. So you could look at a company, say a pharmaceutical company that's based in the United States or in Norway or Australia, it doesn't matter, and you could potentially make a complaint to that country about the behaviour of the company that is based within its borders. Or if a company is engaging in shady practices in a developing country, so for instance in somewhere in sub-Saharan Africa, you could make a complaint about the company's behaviour there. Because again, at the end of the day, the company is only operating there at the pleasure, I suppose, of the ruling government. And as we saw in the Egyptian example, the country refused to issue a patent and that forced negotiations around price. Countries do have some control here. You know, there is some room to move on these things. So you could potentially say that a country that is failing to adequately negotiate with suppliers of these drugs is potentially in breach of the right to health in relation to its citizens. Of course, this is also complicated by the fact that a lot of these countries have GDPs that are a small proportion of the annual revenue of these companies. So, you know, realistically, you're looking at quite differential bargaining power there. But just to summarise, I mean, I think you definitely can utilise international and national mechanisms to improve access to medicines. You've sometimes just got to be a bit creative in terms of how to do it and look at trying to involve the states more because they're the ones that bear the direct obligations. Jordan, you're muted.
I keep doing that. Thank you. That's really interesting, Fiona, and I think, I mean, the New York Times article, I actually haven't fully read it, but I just saw sort of the headline before this call that, you know, Gilead sort of saves the day. And as you say, it is really to be emphasized that this wasn't just a gift from Gilead with no sort of prompting to provide these low costs to the people who need it. You know, there's always some sort of pressure that's required, unfortunately, and particularly civil society pressure to lower prices. Not necessarily in this case, but certainly in bringing prices down and getting the price, getting this medicine generically manufactured in different countries. I'm wondering if we have other questions, comments. We're slowly running out of time. No, Pratik, you just joined us. If you want to say hi, sorry you couldn't join us sooner.
Sorry, guys. Can you guys hear me?
Yeah.
Well, yeah. This is Pratik Chetri. I'm on UAEM's board, University's Allied for Essential Medicines. Sorry, I was gonna be here earlier, but my uncle called from Nepal, and it was kind of urgent, so just got off the thing. I just wanted to listen mostly. I don't have any question right now.
Okay.
But it sounds like you're talking about what sofosbuvir or.
Yeah, we were just mentioning that in terms of how you could approach complex issues like that through human rights framework. Wrapping up, one question that I would have is sort of on the side of the tactic, as you say, that they're using to where patients have to open the bottle when they pick it up and then have to return that bottle to refill it. I mean, that in itself is sort of bringing in other people into the doctor-patient relationship. Do you foresee any, potential issues that might come up there? This might be putting you on the spot a little bit.
Sorry, it was a little patchy. Could you say it again? Sorry.
Oh, I just asking Fiona.
Yeah, it was a little patchy. Sorry.
I was just asking a question to Fiona. I don't know if she heard me.
Sorry. I mean, look, I think that the question in relation to that is, it's a tricky one, and certainly the New York Times piece does address the fact that, some patients actually do support the policy whereby they're required to actually open the bottle, because as one of the patients points out, there would be a pretty enormous temptation to then go and just resell the medication given the price that could be obtained for it. But I mean, look, there's no doubt that it does create significant ethical issues. I mean, it's, I suppose, an unusual circumstance of a company imposing a requirement like this, actually in the pharmacy. Certainly governments have been able to do this before in respect of things like opioid substitution therapy, where patients are required to take things like methadone in the pharmacy to ensure they've actually taken it, so supervised administration. And as well as that, supervised administration of other drugs and programs like DOTS for tuberculosis control is not unheard of, but a company requiring it is definitely a new step. I mean, as to whether it's a really significant human rights violation is, I mean, it's a difficult question. I do agree that Dr. Jennifer Cohn's point that it's an incredibly dangerous precedent is probably correct. But I mean, to be honest, I'd be interested to see how this plays out. It definitely does create ethical issues, but it sounds as though the recipients in Egypt aren't exactly kicking up a fuss about it, because I think they're probably just happy to have access. So, I think we have to perhaps temper our own, judgment in respect of this. And if we're looking at a human rights-based approach and, participation, I think it's really important to ask patients what they want. And if this is the condition of them getting access to a life-saving drug, then perhaps they would, prefer that. But I guess that the argument, on the other hand, is effectively that companies just shouldn't be allowed to impose these kind of conditions for patients to receive life-saving medicines. So it cuts both ways.
Yeah, great. Do we have any final questions? Comments? Stories? All right. Well, we hope to continue this conversation with you, Fiona, moving forward, particularly in relation to our Multiply Change campaign that we just launched. So a brief plug for that is that our Multiply Change campaign is raising funds for a program called our NextGen Leaders program. And so that's a train the trainer model that we first carried out in March here in Boston with different members of YP-CDN from Kenya, Rwanda, Nigeria, and India, and from across the US. And so that is really to train on direct action organizing, advocacy strategies, and now also couple that to technical access to medicines knowledge. So what are essential medicines lists, how they be influenced, and specifically in the case for this campaign, we're raising money to bring this training to Kenya. And so in the Kenyan context, we have connections with the Ministry of Health, specifically the people leading the NCD unit, as well as other NGOs that are familiar with the access to medicine space and the policy influence in the country in that regard. And so we'll be bringing in those experts locally to share that local expertise and really work with our YP-CDN members on the ground in Kenya to push policy and social change in relation to access to NCD medicines. And so specifically what projects they'll be working on will be determined by the leaders on the ground. And so we do have the people that are ready to go and excited and all the technical expertise, and we just need support from you via donations to make this training happen and really launch more activism on access to NCD medicines. So thanks for everyone for joining us today, and for those who are watching live, please do continue if you're interested in contributing to this discussion, or if you have any questions for our speaker Fiona, or for anyone else through YP-CDN, we'd love to hear from you. And so thanks again to Fiona, and looking forward to continuing discussions and sort of strategizing how we can improve access to medicines together. Bye, everyone. Thanks.
Thank you.